And in the particular cases at the Supreme Court, they're young girls, like as young as middle school, where they're treating them like boys. So changing their pronouns, changing their names, allowing them access to locker rooms and bathrooms of the opposite sex, and then purposefully hiding that from the parents. And so they'll go so far as to have two sets of records. So one set of records inside the school that they're using the different names and pronouns. And then when they correspond with parents, what they'll do is change it and go back to the original name and the original pronoun.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty, particularly from the perspective of faith-based nonprofits. In lieu of our normal Monday weekly episode, we have an exciting special episode here today where we're joined by our esteemed guest, Attorney David Cortman, who's Senior Counsel and Vice President of Litigation at the Alliance Defending Freedom, which is a religious freedom organization that really doesn't need an introduction for our listeners. David's been practicing law for nearly 30 years and has argued and won several times at the U.S. Supreme Court, as well as, of course, elsewhere. So, David, thank you so much for joining us today to discuss religious freedom and specifically religious freedom related to parental rights and public schools.
Good to be here. Thanks for having me on.
Yeah, well, you're most welcome. Before we get into the substance, we wanted to give you the chance to maybe introduce yourself to the listeners and tell us a little bit about yourself, your practice, anything you'd like to share before we kick it off.
Yeah, absolutely. I have a great job. I get to defend religious freedom. I've been doing so for about 3 decades. I've practiced in all courts, from trial courts all the way up to the Supreme Court. Working with ADF is fantastic. We get great allies like you all to work with in what we do, and it's impactful work. When I went to law school, I wanted to do something to make a difference for my faith and make a difference in the culture, and certainly we've been able to do that. So it's been really a great run.
Great. Before we go into the substance of the conversations we want to talk about today on public schools and parental rights, just curious, do you have any case that stands out to you as a favorite that you've gotten to work on over the years?
Yeah, I mean, I don't, only because I have so many. Like, I'm one of those people where they say, "What's your favorite book?" I'm like, "I don't have one." Or, "What's your favorite movie?" I have a ton of them. But what's been neat over the years, obviously, you mentioned, I got to argue a couple times at the Supreme Court. And that's the show. That's the big thing that litigators strive for. So that was probably the coolest experience in my life, just as daunting as it was exciting. So that was fun. But we have tons of great cases, tons of great clients. It's really nice to practice in a field that you believe in, what you advocate for. Makes it easy to be zealous. So yeah, it's been one of those things where we've got so many Supreme Court cases. ADF has won, I think, 16 in the last 10, 12 years. So it's just great clients and great cases we get to work on.
Wonderful. Thank you.
Yeah, it's great. We're so grateful to have someone who's done all the incredible things you've done for religious liberty on today. So with that, we'll start to kind of dive into things. So David, I loved reading your recent article in National Review based on your comments from the Religious Liberty Commission's hearing. So that offers the principles you outline there give a great starting point for our conversation today. So before we start getting into more specific cases and different laws, could you tell us a little bit about the landscape of religious freedom in public schools? What are some areas of concern? What's the history of religion in public schools, and how is it different today?
Yeah, what's interesting, there's probably been 3 stages or 3 periods for religion in public schools. And I think the first one was when schooling started in our country. They used the New England Primer, and it was all about Bible verses, and they taught you how to read and letters and the alphabet. So the very beginning of our country, there was a lot of religion infused in teaching. Then we moved over the last, the mid part of our century and then closer, and the Establishment Clause all of a sudden became this giant monster that I think in the law and from the courts was exaggerated beyond what was intended to be. And so for several decades, the court was clawing back that religious freedom in the public schools and saying, well, this is sponsoring religion or violating the Establishment Clause because it's promoting religion. And I think that was an erroneous period, because I don't believe the Establishment Clause requires that. nor do I believe that's the proper reading. They would say that there's a conflict between the free exercise clause, which is meant to give the most robust freedom to citizens, and the establishment clause, which is meant to curtail it. And somehow the founders drafted this provision in the First Amendment that's actually one phrase and somehow conflicts with each other, which doesn't make any sense, right? They're meant to complement each other. The establishment clause basically is a restriction on government, and the free exercise clause is promotion for the free exercise of the people. And so that stage was decades of clawing back on freedom of religion through all the cases and laws. And now, over the last decade and a half, maybe a little more, we're back to what I think is a proper reading, and that is full and robust freedom of religion in the public schools, especially by the students, even teachers in certain instances, and even the schools. You don't want to promote a particular religion, but you want to allow the freedom of religion to thrive and not be the enemy of religion like they often are. And that, by the way, still is occurring, but I think we've come a long way from where we were.
Yeah, that's a great starting point to dive into some specific cases. I always marvel at this when we talk about, especially in the commentary that led up to the St. Isidore case over the last year or two, the looking into the origin of the public schools. As you said, not only were they using scripture to teach, I mean, I think not even arguably, I think pretty obviously the original model of the public school was a non-denominational, but it was a Christian-inspired school, right? Not a particular denomination. It's not like a Methodist school excluding the Baptist schools or what have you. But I mean, they were praying the Our Father and reading the King James Bible. I mean, there was religion, like you said, totally infused into the way that schooling was offered. And so it's heartening to see that we're, I think, moving past what you kind of called like that second era of law on religion in the schools. So there are a lot of different avenues we could go down now talking about religion in public schools. But one thing we'd like to discuss, because it's in the news, there are some cases coming up involving school policies that promote like social transitioning students, especially against parents' wishes, sometimes actively lying to parents about these kind of social gender transition cases. So what are some of the arguments that defenders of religious freedom should be aware of and should make against these kind of policies? And is ADF involved in any of these disputes in particular?
Yeah, very important issue. We are involved in several. We're involved in one at the Supreme Court, asking the Supreme Court to take the case. And there's several of those. And we also have several at the district courts and the Court of Appeals. So I think we have about 5 of them now. What you're mentioning are these secret social transitions. And I think the most dangerous part of them, regardless of how you feel on the issue, is what they're doing to hide this from parents. And that, to me, is the most egregious surrounding of all of this. And that is, if a school is going to do something this serious to a student, whatever side the parent is on, they need to include the parents in the decision. And these type of policies, they're actually secretly transitioning these students. And in the particular cases at the Supreme Court, they're young girls, like as young as middle school, where they're treating them like boys. So changing their pronouns, changing their names, allowing them access to locker rooms and bathrooms of the opposite sex, and then purposefully hiding that from the parents. And so they'll go so far as to have 2 sets of records. So one set of records inside the school that they're using the different names and pronouns. And then when they correspond with parents, what they'll do is change it and go back to the original name and the original pronoun. And that, to me, is just, not only is it wrong, it's just and constitutionally a violation, but just egregious behavior.
You know, I think I know Joseph wants to ask about Mahmoud. So I think you're seeing the ideological split over how schools ought to interact with kids. I think it came out really strongly in Justice Alito, the beginning of his opinion in Mahmoud, and then the intro of, who was it, Justice Sotomayor who wrote the dissent? Yeah. The way that they frame these, if you read the beginning of Justice Alito's opinion, he's talking about what I think is the correct and the traditional, certainly the Christian understanding that parents are the educators of children and schools are an aid, a vehicle, right, to help form them. Whereas the way I read the beginning of Justice Sotomayor's dissent is very disturbing, because it looks more like public schools are the educators of kids and parents have certain rights to object to certain things or choose certain things. But to me, there's a sharp distinction there. Who's really in charge of forming kids? If it's schools, we're in a bad place.
Yeah, and that was my original point. Regardless of where you are on the ideological spectrum or on this issue or any other issues, what parent would say, "Sure, take my kids, do whatever you want, and not only don't tell me, go against my wishes after I find out and inform you, and don't let me know." So that's the part where I don't get it sometimes why there is an ideological split, whether it's in the court or the country, where you would think most parents would say, "Look, whatever you're going to do, I want to know and I want to be involved."
Yeah, absolutely.
Yeah, it's come up a few times now, Mahmood, so it's a good time to dive right into it. So one of the biggest decisions from the Supreme Court's last term, our listeners likely know it's the court basically ruled in favor of parental opt-outs from these books that discuss sexual orientation, gender identity, and shifting pronouns and these sorts of things. And a lot of people after that decision were hoping that it would have a big impact. So we'd love to hear a little bit more about what is the kind of trickle-down effect we're seeing from Mahmood. Is this logic finding its way into these lower arguments and decisions?
Yeah, I mean the opinion is so new. It hasn't started to yet, but it will, and we'll be working on cases to make sure that it does. But it was a great opinion because it was a sea change in the way the court treated curriculum issues. So up until that point, most courts would say, well, look, if they're teaching a curriculum and you're just learning about it, just because you disagree or you're offended by it or it violates your religious beliefs is no reason to be able not to hear it or not to opt out. It's just part of the curriculum. This is what we do. So the great part about the Mahmood case is the court said for the first time, no, when you're engaging in even this curriculum type material and you're teaching it to the students and impressing upon them, this is the right way to think about these things. And the way you think about them, religious people or people who just disagree, is wrong. That's coercive to students and pushing it on them. So the great part about this is that we're going to take this opinion and make sure that school districts across the country respect that. In fact, there's some school districts we're looking at now up in the Northwest that are already doubling down even after Mahmood say, well, we're not allowing opt-outs and whatever's in our curriculum as far as the LGBT stuff we're going to keep there. And they're just they're ripe for a challenge and just asking for it. And we're certainly going to bring it.
Do you think that some of those cases are close enough on point to Mahmood where you're going to see the Supreme Court grant cert, vacate, remand, or are these going to be new facts that are going to require further argument?
Yeah, I mean, sometimes, and if you think back and y'all remember Mergens and the Equal Access Act in the 1990s, and that basically said, look, if you have other clubs at schools, you have to allow Bible clubs. And so you have the law that goes into effect by Congress, you have the Supreme Court ruling, but then it takes like a decade to implement that. So you have school districts all across the country coming up with all these what they think are clever reasons not to allow a Bible club at school. And so you end up litigating that to make sure that it gets entrenched. And so I think the same thing's going to happen here. Whether the court will take another case, whether the Court of Appeals will be calcitrant, whether the district courts will follow Mahmood, we'll certainly see. But I would imagine there'll be decisions going both ways. And it wouldn't surprise me if some years from now the Supreme Court takes it up again if there are conflicts in the circuit. So whenever district court or circuit courts rule different ways, it's the Supreme Court's job to make sure that the whole country abides by the same law when it comes to federal law and the federal Constitution.
Right. Yeah. One of the follow-ups I have on Mahmood is, so on one hand, Mahmood's dealing with the particular facts, right, of opt-outs from these very troubling LGBT curricula for elementary school kids. But one of the things that Justice Alito, I think, made pretty clear in Mahmood is that Wisconsin v. Yoder is alive and well and should be interpreted beyond its facts, right? This is not just some weird rule for the Amish and their beliefs. So do you see other ways besides these kind of gender program opt-outs where Mahmood is going to be a relevant precedent to start to set up some more robust religious liberty, parental rights cases?
Yeah, I do, because if you look back to Yoder, it hasn't really been cited much in the last 20 years or more. And so, putting the teeth back into that, say, no, that wasn't just limited to whether Amish people could not attend, high school so they can go work in their communities and learn their way of life. It's bigger than that. It applies across the board, and it applies whenever there's some substantial encroachment on religious freedom. And so clearly it will apply even beyond curriculum, even beyond this particular issue. And I think that the good part about that is, and as you mentioned, that the court opinion and Justice Alito they acknowledged that the response by the school was, well, go to a private school or be homeschooled, and the court said, no, that's not an option. This is a violation and a penalty on the exercise of your religion, because if there's a public benefit, they actually cited the Trinity Lutheran case that I had the honor to argue, but they cited that case to say, look, this is a public benefit, and if you're penalizing the exercise of religion through that public benefit, that's a violation of religious freedom. So I certainly think the opinion is going to carry much more broadly than just curriculum and just at the younger ages. That just emphasized how inappropriate it was to be bringing this type of material and imposing that upon 5-year-olds or 6-year-olds, which is, shows one of the problems going on in public schools today. There seems to be not only these major constitutional violations, but no common sense. I mean, why are you bringing sexual issues to a 5-year-old or a 6-year-old? That's just completely inappropriate.
Yeah, I actually think that watching or listening to the oral argument in Mahmoud, it was a good public teaching moment that we had these really awkward exchanges, right, with justices asking the Montgomery County attorneys about, bondage and leather and all these disturbing, and I think it was a good thing for the public to see that this is a conversation we're having about what we're teaching elementary school students, even aside from the precedent being set by the case. Because like you said, this is just so inappropriate that I think more people need it to be spotlighted.
Yeah.
So,
and I think one of the other things it shows is, the left tries to say, well, we're teaching kids how to be tolerant and to get along with each other. And the two problems just right off the top of my head about those things are, number one, you're not being tolerant of those people who disagree with whatever you're pushing. So it really is not tolerance, it's intolerance unless they agree with you. The second thing is, kids that age don't know anything about this stuff. And so they're already, playing with their friends, doesn't matter who they are, what they identify as, what color they are. And even dealing with racial issues, a kid doesn't know color difference unless you tell him there's a color difference and then tell him there's a problem with it. And so you actually push the exact thing that you say you're trying to eliminate. And I think that's one of the disturbing things going on, especially at the younger ages.
that's a great point. That's a good goes beyond law into like educational and childhood psychology, right? Little kids don't need abstract, deep ideological conversation. They need to be taught what is, and to just learn kind of basic things. This is
Right.
inappropriate for that age group. That's right. So before we go into the broader religious liberty movement, I was just curious, do you see, besides the LGBT kind of stuff that we've just been talking about, what are some of the other problems and challenges involving religious freedom, particularly in the schools right now, that are on your radar?
Yeah, oddly enough, the reaction of, no religion belongs in schools is still alive and well. And what's odd about it is that the Supreme Court has taken care of that for 10 to 15 years already. Like over and over and over again, it says, look, religion is fine as public schools, especially when it comes from the students. Teachers can do it in certain times and areas. But when it comes to the student, they have rights across the board, whether they're talking to their friends about their faith, they're wearing religious clothes, they have religious clubs, they're posting religious things, on an equal basis with everything else. And yet you'll have these silly instances where, one of our clients during COVID, they had masks that people were wearing. They were allowed all kinds of messages on masks. And, this middle school cute little girl has the nerve to wear a mask that says, Jesus loves me. Well, you would have thought, she violated some giant school policy and constitutional principle. And their response was, rather than saying, okay, we let masks of all different types of messages be worn, this is fine. They basically say, no, it's not only violates our policy, but it's illegal for you to wear this. The odd thing we found out after we filed the lawsuit was they didn't have a policy that prohibited it. It was a knee-jerk reaction to this, you can't have religion in schools. They actually changed the policy to prohibit it after they told her she couldn't wear it. So they backtracked, covered their tracks, and said, well, we have a policy that says no religion. It actually said no politics and no like sexually suggestive messages. And so they kind of did it after the fact. But the point is that reaction of no religion in schools still is prevalent, even though there's no justification for it in the law whatsoever. And the court actually has gone the opposite way to say, no, you have to allow this over and over and over again. So the question is, why isn't the message getting out?
Yeah, that's a great point. I'd be interested to hear people making these policies being pressed on this, because I guess ultimately they would have to say wrongly that to allow a student to wear a Jesus loves me mask is an establishment clause violation, right? The school, by letting a kid wear a mask with that message, is establishing religion. Is that the argument?
Yeah, that's the argument. And or your a derivative is you're imposing your beliefs on someone else, which is also odd because everything the school does imposes their views on all the kids, and
Right.
kids should be allowed to speak about various issues, especially when they're allowing the debate to start. We had a case, a T-shirt case in the Northeast, and the school was pushing Pride Month and gender ideology and saying, like, there's an unlimited number of genders. And they were pushing on all the kids. And my client wore a T-shirt that said there are only two genders. And so they banned that and said, well, you're pushing your religious views on everybody else, and this is intolerant. And our question was, well, you're pushing your views on him. And just because he disagrees, why aren't you being tolerant of his and everybody else who thinks like him? So the whole, intolerance and pushing your views on everybody else, it's okay for them to do it or other students to do it who agree with them. But the minute you disagree, all of a sudden you're the one who's pushing your views on others.
That's a great point. I don't want to articulate something that I'm just thinking through now on the camera, but it is worth getting into just for a minute. There's a really interesting, it's not a tension, it's a contradiction that you just pointed out. So I think on one hand, you have this very aggressive kind of secular culture that says if there's any kind of religious message and we allow it in a public institution like a school, that's a religion, that's an establishment clause problem. But at the same time, our courts, and this is a pet issue of mine, but in the last few decades have gotten very broad and jumbled about what a religion is, right? Where groups like the Satanic Temple, who are atheists, who basically admit that they're just using this organization to push political, ideological, like liberal agendas as a religion, but they're granted religious protections. So if all of these things are religions on one hand, how come they're not banned by these same establishment clause arguments that would kick, a Jesus loves me mask out of a school? That's a real problem.
Yeah, and it is because there's two things. So the first thing is we want a broad definition of religion in our country because we don't want minority religions to say, well, that's not legitimate and you can't practice this. And I think that's right. The problem, though, is sometimes I think they go too far, like you're mentioning, like the Church of Satan. When you look at them, they're really there to mock religion. And so it's not like a separate religious belief like other, religions are. This is just, like you said, it's political, and it's also not even religion. It's just mocking religion. And so, in my opinion, that they shouldn't, be allowed to consider themselves a religious belief, religious organization, because mocking religion is just simply not a religion.
Right. I think that's exactly right. Joseph, do you want to get a little bit into the larger religious freedom question here?
Yeah, so in a lot of these cases that we're talking about today, and really in schools in general, the religious kids and parents aren't asking for any sort of special treatment, right? They're really just asking to be treated the same as everybody else. And I think that fits as a good segue into kind of the last section here is how do these disputes in schools fit into the larger religious freedom movement? How do these expand beyond just parental rights and get more at religious freedom?
Yeah, and I think they're the starting point of what happens in culture. And so that's the part, people try to separate, different types of areas in our country. Like you have education in schools, and you have work, and then you have the politics and the culture of things. And the reality is they're all interrelated. What's happening in the schools spills out into culture and forms culture. And especially when you're training students that when they're young, they grow up to become politicians, judges, people in the media, all different fields, attorneys, educators, you name it. And so I think the left knows that well. And so they're trying to get them when they're young, which is why they do sort of these types of things that I think are inappropriate at those ages, but they know you got to get them when they're young. And so what happens is that gets pushed in elementary school and middle school, then high school, then you go to college and you get the same type of things, and then it spills out into culture. So these types of battles, if you will, must be taken on immediately, not only because they're imposing their values on the rest of us and parents of all different stripes, but that's how they're training the kids. And so we've got to make sure that if you're not settled with things going on in school, go into school and speak about it. Get involved in your school. One of the things, as I mentioned before, schools are pushing parents out. And the reason I think they're doing that is they don't want the accountability. They want to say, like, look, we know better than you do how to raise your kids, which is a scary thought, regardless of where you stand on the politics of it. And so just leave it to us and mind your own business. Well, obviously, our kids are our business. And so it's important for people to step in and say, no, we want to be involved. We want to know what's going on. We want to have a say, because all of that does move into the larger culture, whether it takes a few years or whether it comes out of college or whether it's people already in the workplace.
Yeah, I'm a Virginia native, and we're seeing in a lot of these school board meetings with kind of everything that's been going on in Fairfax County and these other really, really problematic counties, is that parents will come up in these school board meetings and they'll make their point, and then while they're speaking, either they'll cut their mic or they'll call for a recess as soon as they're finished. So there's no follow-up, and it just ends there.
Yeah. Yeah. And that's, those are often violations in and of themselves, not only of the school's policies, but of the First Amendment rights of the parents who are speaking. And that's why it's good, just like your podcast, and to educate people to say, look, okay, I didn't realize they can't do that to me. So how do I take a stand? How do I push back? Whether it's through, elections are gigantic, even at the local level with the school board. How much power the school board has over your children is tremendous. Becoming involved, make sure you're voting, make sure you're looking at legislation and policies, make sure you're looking at litigation. It takes everything to make sure that we're able to say, look, this is wrong, and we're just not going to allow you to do this because my kid happens to go to your school.
Yeah, it's a great point you make about the problem of normalizing government institutions over parents, over families having these decisions. Because you're right, that can trickle into the rest of life really easily, right? If people start to get used to it's primarily government schools, not parents, that educate children, is it also primarily medical institutions and governing boards that decide when you should be treated for an illness, when you should die, these decisions have ramifications beyond school. That's a great insight. Before we wrap up, I just had one kind of final catch-all question. You've obviously had your eye on the religious liberty movement for, you said, about 30 years now in the legal sphere. So what should people who care about these issues be looking at? What are some of the big frontiers that you see coming up in the next few years?
Yeah, one of the biggest encroachments on religious practice, whether it's in schools or in business or in religious ministries, what have you, is this idea of discrimination. So the left likes to say, people are discriminating based on whatever protected category they want to throw into the mix. It used to be race, religion, sex, national origin, and now they throw in whatever politically speaking they want to throw in. And so religious organizations and religious people, they say, well, when you're a religious school, for example, and you only want to hire people of the same faith, you're discriminating against everybody else. So they label it discrimination when it's actually the free exercise right, the freedom of religious organizations to be religious. Because if you have to hire someone who doesn't follow your religion, then you're no longer religious. And so this discrimination, whether it's in what public accommodation laws, like if you're hiring people, or ministries like K through 12 or whatever it happens to be, what they're trying to use are all these different types of discrimination laws to say that now you're kicked out of whatever government benefit this is, whether it's like a school lunch program. We have cases, we had one in Florida, we have some out west in Colorado, and they'll say, well, you as a religious organization, even though you're a social services organization, and for example, whether you're in adoption or whether you're doing, we have a ministry we represent that helps troubled youth. They mentor them, get them jobs, get them off the street, those type of things, make them responsible citizens. And they'll say, well, because you only hire Christians or people of the same beliefs, you're discriminating. And so therefore we're kicking you out of this program. Now, the irony of that is they're hurting the very kids that the ministries are there to help, because the success rate of these religious groups is fantastic. They're bringing kids off the streets, off of drugs, getting them jobs, making them productive members of society. And solely because they're religious, they're saying, well, you can't be religious, and so we're going to kick you out of the program, when they're not only hurting the ministry, but they're hurting the kids they're trying to serve. So the point is that this discrimination thing that religious groups do, according to the left, is that new field of should you lose your government benefits, kick out of social services programs, no longer get tax exemptions on your property, those type of things. So it's not only here, but we're going to be continuing to fight that, because I think that's the direction where things are going. That if you don't allow anyone and accept all that the left throws at you and basically get rid of or water down your religious beliefs, then you can't participate in society, even though you're a very productive member in all those social services fields.
Yeah, that's interesting. The discrimination thing, maybe I don't think I'm being naive here. Don't all mission-oriented organizations discriminate in their hiring? Like if I were to apply to a left-wing nonprofit or public litigation firm, I'm pretty sure they would discriminate against me for my conservative beliefs and not hire me, even if I'm the most qualified on paper. Isn't that kind of normal practice?
It is, and you look at the word discrimination, and obviously in our country, it carries a negative tone. But discrimination is just like I discriminated on the tie I picked this morning, right? When I'm looking through and I choose one, that's discrimination. But it's always used in that sense of, well, if you're discriminating, it's negative. But all groups do, regardless of what your beliefs are, your politics are, because whatever you're formed for a particular cause or service, you want people who are like-minded, so you further your cause or service. And so it's like, is PETA going to hire a meat eater? It's across the board, regardless of whether it's religious or not. That's the whole point. And the Constitution gives you free association rights, and that is to gather around like-minded people to pursue some particular objective. And so, although it's used, negatively when it comes to religious beliefs, all groups on all sides on all issues do so, and they have a right to do so, because you want to further that objective. If the person doesn't follow what you believe in and what you want to do, then your objective isn't accomplished.
Yeah, great point. Last thing as we wrap up, are there any cases that you or ADF currently has either? I believe the Supreme Court has granted cert in a couple of cases ADF is on. Anything you want to highlight that's coming up in the next few months?
Yeah, yes, we've got an argument coming up in about a week that my colleague will be arguing, Jim Campbell. It's called Childs versus Salazar. And this is one of those counseling cases that are in probably 20-something states across the country, where they basically say that when you're a licensed professional counselor, you basically can counsel in different areas when people come to you for help. The states actually ban one side of a counseling session. So what I mean by that is, if a minor comes in and with the approval of their parents in all these cases, but if a minor comes in and says, look, I want to identify as the opposite sex, then the counselor can counsel them and encourage them to transition, and I'll put that in quotes because there's no real transition, but to identify. If you come in as a young man and you say, well, I want to identify as a young lady and I want to change my name and pronoun, the counselor can counsel you that way. But if you come in and say, look, I've been identifying as the opposite sex, I want to go back and identify as my biological sex based on my religious beliefs or otherwise, it's illegal for the counselor to do so. And so it's completely one-sided, one direction only. You can counsel them away to transition, but you can't counsel them back. And that violates free speech rights and free exercise rights and all these different parental rights. And so we've got a case at the Supreme Court where my colleague is arguing in about a week on that particular issue. And we're hopeful the court will land the right way to say, look, that's a violation of the free speech clause to say you can only counsel in one direction. You can't counsel the other way. And the government has no business reaching into that private counseling session and say, counselor, you can only counsel this way. Even if the client wants to be counseled the other way, you're not permitted to do so. That's the most current one and the biggest case we've got going on that's coming up. But like you said, there are several others.
Yeah, that's a really important case. We'll be watching that one closely. Well,
Yeah.
David, I want to be respectful of your time, but thank you so much for joining us today to unpack quite a lot on religious freedom and public schools, parental rights. And we're so grateful for your time and expertise, but especially for your work on the ground in the courts over the years. Thank you.
Well, I appreciate it. Thanks for all that you do, and thanks for having me on.
Oh, anytime. So thank you also to our listeners for joining us on this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, as always, we encourage you to like the podcast, subscribe to our channel. If you want to support our work, and go to napalegalinstitute.org, and we appreciate your generosity. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you all next week. Thanks for joining us, and God bless you.